Well, actually, hold on. I know I have audio.
Furthest left is in
I think they're knocking on the window.
Are they good?
Media room, can you hear us? They're holding up a phone.
Oh, yeah, we're good.
Should I call in the room system now?
You're on the room system? Do you need to record or?
I'm hovering over the call button. Do it? All right, calling.
He said call him. He said call him.
Oh, look at that.
For teleconference. Does you want a teleconference? Yeah. Okay. I didn't get that.
Are we good to go?
No, the video on?
We always bring it in just in case.
Anything else you want to ask? Do you have to record this or no? Do you need to record it?
Supply the information in the plane. Ouija board. Probably shouldn't say that.
Thank you, guys.
We're good to go.
All right, please bring them out.
Thank you.
Thanks. Call, State of Wisconsin versus Nikita Casap. This is 25 CF 435. This matter is tabbed. The Honorable Ralph Ramirez. The matter is currently in warrant status. Appearances, please.
State by Leslie Basie.
Nikita Casap appears in person and in custody with attorneys Maura McMahon and Nicole Ostrowski. Good afternoon. We are in receipt of the criminal complaint as well as the amended criminal complaint. I would note the amended criminal complaint, it appears it's just a modification of dates within the probable cause section. The address on the complaint is accurate for Mr. Casap. He is eligible for public defender representation, and at this time I would be making an oral motion to dismiss based on my review of the criminal complaint. I do not believe that there is sufficient information within the four corners to support the two charges, specifically with respect to the portion of both counts where there is an allegation that these things happened without consent. There is nothing that I can see other than one sentence at the end that says, based upon information and belief, victim A did not give the defendant permission to operate the VW Atlas, nor did he give consent to remove the Smith & Wesson 357 Magnum, excuse me. So based on that, I would move to dismiss at this time.
Counsel, do you acknowledge receipt of the victim witness identification key?
I do.
Does your client currently, are you going to keep this case? Or
Yes.
Okay. All right, young man, these attorneys are going to represent you today and further after today, because you do have a right to an attorney in this matter. Does your client have a phone number we can add to the court file?
Yes, 262-875-0323.
All right, and just for the record, you come accused before you do the Four Corners Challenge. You come before the court being accused of 2 counts, operating a motor vehicle without owner's consent. If convicted, you face up to 6 years in prison or $10,000 fine or both. Count 2, theft, movable property, special facts. You face up to 6 years in prison or $10,000 fine or both if convicted. The court has reviewed a copy of the criminal complaint, and this is a felony, and there's a challenge that has been brought forth by defense counsel to the facts being alleged not supporting this matter going forward to a preliminary hearing. So that being said, state, what is your response to the challenge being brought forth by the state, by the defendant?
Here we'd ask the court to deny that motion. In this case, what's alleged to have occurred is that the police went to the house the defendant formerly resided at. He is no longer welcome at that residence. His stepfather and mother were found We believe it's them. They now have been positively identified as his stepfather and mother were found deceased, shot. The stepfather was shot in the back of the head, and the mother had 3 gunshot wounds, 1 close up to the neck, and then 2 others that were non-fatal. Obviously, a dead person cannot give consent. We believe that the date of violation, although it's not in here, the date of death is on or about February 11th, 2025, which means that the defendant was living in the house with his deceased mother and stepfather for a period of time up to February 23rd, based upon the fact that and I believe that there was a neighbor who said that I don't even think the defendant had a driver's license to be able to drive a car. So based upon that and the fact that he was underage, I believe the inference is that he did not have consent to either take the firearm out of the house or the car. Obviously, the person that would have had to give him consent is dead, and we believe forthcoming charges will be brought accusing this defendant of causing that death. So at least for this hearing, we do believe that the motion should be denied. The 4 corners of the complaint adequately establish probable cause to believe a crime has been committed and that the defendant committed that crime.
Your rebuttal to that response.
Majority of what Attorney Basie put on the record is not listed in the criminal complaint, and that's what the court has to decide this motion on. Whether or not a felony was probably committed by this individual, that's a preliminary hearing standard. That's not the motion that's been brought today. I believe that there is a lack of information within the complaint to support the 2 charges as noted. Specifically, what Attorney Basie indicates is a completely separate charge that's not within the complaint, especially 2 separate charges. Whether or not the individual had a driver's license does not go to the elements of operating motor vehicle without owner's consent. So I would continue with my motion and ask this court to dismiss both counts.
When the court's presented with a 4 corners challenge to a criminal complaint, the court can make reasonable inferences from this complaint as to what the defendant's being accused of. In this case, he's being accused of operating a motor vehicle without owner's consent, as well as theft. Special facts. Court notes that this vehicle, he was recovered in another state. This vehicle, there is no clear consent here. In fact, I understand that he is not here on other charges. I should look at what he's charged with. Obviously, I can make a reasonable inference no consent was given because the person or persons, I have to ask a clarification here. This is his biological mother who is alleged to be one of the victims?
Yes.
Well, the people who could have given consent are not alive. So it's a reasonable inference that no consent was given. Furthermore, there's no information here to believe that the firearm that was recovered in his possession, there was consent for him to, 1, have it, or that his actions demonstrate that he had any permission whatsoever. So we're making reasonable inferences on the face of this complaint. The court will deny the motion to dismiss. I will make a further finding. I do make the finding that there are sufficient facts to set this matter over for a preliminary hearing. So as such, on behalf of the state of Wisconsin, I will take your bail argument at this time.
Thank you. Judge Bourne did sign the arrest warrant on this case after reviewing the probable cause in the complaint, and he signed it with $100,000 cash bail. Certainly, I believe that's the minimal amount that should be ordered by this court. However, since this complaint has been issued, we certainly have much more information. We have downloads of electronics. We have downloads from applications that the defendant was using, and certainly the defendant will be charged with 2 counts of first-degree intentional homicide in the very near future. I'm just waiting for a couple warrants to come back. Further, the defendant was communicating via an app in either Russian or Romanian. We're not sure. The FBI is helping us to translate those communications. I can tell the court the defendant had $14,000 in cash on his person. He also stopped at least 1 Bitcoin machine and made 12 different transactions through that machine. That is not money that you get, but it goes into a wallet that he presumably has access to. We are asking for $250,000 cash bail, that he be ordered not to leave the state of Wisconsin. He not use or possess any type of dangerous weapon. The defendant was born in Moldova. He came to the United States approximately 10 years ago with his mom. The allegations, again, involved the defendant leaving the residence, last seen at the residence on February 23rd. The last time either the victim A or victim B was seen alive would be February 11th. I believe he stopped attending school on February 12th. We do believe that the two victims were killed on February 11th. The defendant continued to live in that residence with the two bodies in the house. He then fled with the $14,000 in cash. We know that he was communicating with someone indicating that he had the name of a person to get fake plates from to put on the car in order to obviously hide the fact that the car was stolen. We know victim A and victim B both had injuries consistent with gunshot wounds, as I described before. The stepfather had a contact or near contact wound to the back of his head, and his mother, victim B, had wounds to her torso, as well as we believe a close gunshot to the neck, which would have been the fatal gunshot. He has no family in Wisconsin. His maternal grandmother lives outside the United States. He does have, through his stepfather, he has family. Victim A has family in Massachusetts. I don't think at this time that they're too interested in this defendant. We do know, like I said, he was communicating in Russian and Romanian. We are trying to work through that with the FBI. We also know that based upon the fact that the defendant had both victim A and victim B's driver's license, as well as other identifying information for his parents, or for his stepfather and his mother, that we don't know what he intended to do with that identification. But we do believe he is a risk not to appear in the future. As indicated, I will be issuing additional charges hopefully in the next week, and they will certainly be more serious, involving the death of victim A and victim B. For all those reasons, Your Honor, the state does believe he is a risk, and we'd ask the court minimally to do the $100,000 that Judge Boren felt was appropriate, but based upon the information we now have, including the lengths that the defendant was willing to go to conceal the car and possibly conceal his appearance by bringing cash and getting Bitcoin, the state does believe the $250,000 cash bail is appropriate. Nothing further.
For the defendant.
Thank you. We're asking for a lower cash bail. I think at most $100,000 is sufficient. Obviously, it's held Mr. Casap in custody. He has not been able to post that amount, but given the nature of the charges that are before the court at this time, I believe that a lower cash bail would be more appropriate. He is young. He's still in high school. He has been in Wisconsin since, I believe, 2017, which is a little bit longer than around about 10 years that Attorney Basie had mentioned. It's my understanding that Mr. Casap has been compliant with law enforcement since our involvement in this matter, noting that, again, we're here on operating without owner's consent and theft with special facts. I don't believe an increase in cash bail is appropriate at this time. Most of what Attorney Basie has indicated would be more relevant to any subsequent charges if they are filed, but at this juncture, I think what the court has before it, a lower cash bail would be more appropriate, but again, at most, the $100,000 has been sufficient in holding Mr. Casap in custody.
Thank you. The matter come before the court today for the setting of bail. We conducted the initial appearance. We did have a challenge. I denied the motion to dismiss. Court's reviewed the criminal complaint, heard the arguments of counsel. Court would note that one of the issues the court does take notice of here is it appears that this individual was trying to flee the jurisdiction of not only this state, but also this country. I can't help but notice that according to the criminal complaint, this individual continued to move further and further away from Wisconsin. Also, I note that it seems like steps were taken by this individual to try to conceal what was going on at his home, the Bitcoin, etc., the cash. A lot of these issues make the court believe that this individual has no intention whatsoever to be here where he is today. In fact, I think it's a reasonable inference given the fact he was going through Illinois, Iowa, Nebraska, Wyoming, Colorado. He was doing what he can to not ever come back to this court, not ever face any charges whatsoever. So I acknowledge the fact he's a rather young man. He's in high school. I understand he's been cooperative with law enforcement. However, the court is very concerned about whether or not this individual having substantial contact overseas, having left this state, tried to get different plates on the car. All these things make me believe he is a tremendous flight risk, which he could not, he would not return to this jurisdiction if given the choice in front of him. So for all those reasons, the court will follow the state's recommendation, set cash bail in the amount of $250,000. Conditions include appear in person for all future court dates, no violations, rising level of probable cause. I'll set level 1 WCS monitoring with GPS to remain in the state of Wisconsin. He shall not leave the state of Wisconsin. He will be released during business hours to be fitted with the GPS, and he will not be allowed to leave the state. He will surrender any and all passports he may have, and will not apply for any other passports during the pendency of this case. And again, he will not leave the state of Wisconsin. Absolutely no weapons whatsoever. Furthermore, if he has not previously had a DNA sample taken, the court orders a DNA sample to be taken from this individual. The car theft case of the DNA case, and as such, he shall be collected from him. He may ask for it to be returned to him under 165.77 sub 4. Furthermore, cooperate with any and all ID processing needed. And as a housekeeping matter, obviously the warrant is quashed that was issued because he's here in front of me and I just set bail on him. So that all being said, for the defense, are you asking for prelims and time limits, or you waive statutory deadlines on this case for a prelim?
I would ask for it within timelines.
Time limits being set, not being waived, we'll set it within the 10 days. State, you made some statements on the record today that additional charges are forthcoming. I know that's kind of hard to estimate, but obviously it would make more sense to get the charges in, or are you amending the criminal complaint or adding a whole new case number?
Actually, what we would ask is that we set this out for closer to the 10th day, and I believe that one option I have is to establish probable cause for additional felony charges during that preliminary hearing and filing information with those charges.
Or I'll leave it to your discretion, counsel. But that being said, Madam Clerk, a date certain then for preliminary hearing.
March 26th at 8:15 or 10:15?
That would not be within the 10-day time limits. I think they invoked the time limits.
Yes, they did. It has to be within 10 business days.
Does the court have anything on the 21st?
I have 10 days listed as March 26th.
Today's the 12th, so the 10 days would be the 22nd.
Yeah, but you don't count weekends. That's
Weekends?
under 11 days. Unless someone wants to correct me on that. What do you want to do, the 21st? What are we doing here?
I'm available the 21st. I don't know if defense is available.
We do not have prelims on the 21st.
Okay.
Otherwise, then I have March 19th, 8:15 or 9:15.
I can do 8:15.
Both of us are in trials.
I will take Madam Clerk's calculation of it's the 26th, and if it's not, then I would waive time limits to go to the 26th. That's fine.
With that understanding, we have availability on that date, Madam Clerk?
On the 26th.
Wednesday, yeah, that's Wednesday, right?
Yes.
That would be Wednesday, March 26th at 8:15 or 10:15.
I actually have a trial on that day. Could we do the 24th?
You can do the 24th at 10:15.
That would work for me.
That's for me.
That's fine.
All right, that'll be the next court date. State anything further on this one?
No, Your Honor.
For the defense?
No, thank you.
All right, that concludes the hearing. I wish everyone well. You have a good day.
It was supposed to be